Welcome to Deals and Disputes with the West Web Law Group.
Hi, welcome to Deals and Disputes with the West Web Law Group. I'm Matt Skye. Today we're joined by Baili Rhodes, a partner at West Web Albritton Gentry. With a background in litigation and extensive involvement in the Texas Young Lawyers Association, Baili now specializes in employment, corporate, and real estate transactions, helping clients navigate and avoid business disputes. Baili, thanks for joining us.
Thanks for having me.
So let's just jump in. A lot of questions when it comes to employment. What are the key differences between employment at will and an employment agreement?
Sure. So Texas is an employment at will state. And that means as an employer, you can hire, fire somebody for any reason at any time at all, as long as it's not an illegal reason. Same thing, employees can take any job and they can choose to leave it, for any reason they want to. So you have sort of fluid relationships between people, and often you hope that they last, but it gives you a lot of flexibility, both from an employer and an employee's standpoint. Some people choose to have employment agreements for a variety of different reasons. Some people call them agreements, sometimes they call them contracts, but that's going to be something that is generally considered binding on the employer and the employee. Define the terms of their employment, the length of their employment. There can be a lot of different things in there, but it's something that's going to take away that at-will nature generally and put some parameters on the relationship.
And what are some of the complexities with each of those very different relationships when it comes to employing someone?
Sure. So I think that, employee at will, there's a little bit of risk if you're hiring somebody, especially that's a key employee. If your company is depending on a person to be there for a long time, if it's going to take a lot of training or effort to put into them, or if you really need them for your operations, you have a little bit of risk if it's somebody that doesn't have a tie to you other than their own loyalty, right? If they could just take up and walk away and they don't have, say, a year-long term or some rules in place as to what kind of resignation they have to offer. On the other side, an employment agreement creates rights. As an employer, especially if you're not really careful about what you put in that agreement, you are taking a person that previously you didn't have to follow any kind of restrictions if you needed to fire them or if you needed to change their compensation or change kind of the rules that govern their employment. Now you've got a guidebook that you have to follow. So whenever an employer is making a decision about whether or not they should have an agreement or have a contract with an employee or keep them at will, they really need to think about that person. What's their value? Why do I want to have more of a structured relationship with them? Is that going to benefit my business in some way? Or is this a person that I need to be able to make decisions about and not have to change a written agreement before I change their relationship with the company?
Now, I'm assuming the answer is probably yes, but let's say I'm an employer. Should my employees have contracts?
It depends. I wouldn't say if you've got, maybe administrative hourly employees, people that perform just kind of day-to-day jobs, probably not necessary to have contracts with them, because what I tend to see is people have a lot of trouble getting out of contracts. They hire someone that has an easily replaceable job, is a better way to say it. They do a contract with them, then they need to get rid of that person for whatever reason, and it's a big challenge. If you're hiring more key employees, executives, people that are going to be part of your leadership team, I see it a lot in medical practices, folks that you're going to be in a world of hurt if they walk out the door, and you're unlikely to be in a position unless it's, for cause they did something really wrong where you want to get rid of them immediately. You're going to be better off in those situations to have a written agreement. Additionally, your highly compensated employees, they tend to be people that expect to have some plan and structure in their employment. And so they may want to have an agreement and they may push for that so that they know what their expectations are. And you as an employer are bound to follow those expectations. But really depends on your people. I know a lot of small businesses jump into thinking, because I read an article, that everybody should have an employment agreement. I see a lot of those same folks that find one online that was prepared by another business owner. And often those are not great for the business, because now they're stuck with somebody that maybe they should never have had a contract with in the first place.
What are the benefits when you do have a contract to the employer, and what are the benefits to the employee?
Sure. So for both of them, it's going to define the structure of the relationship. There are some agreements that maintain that at-will nature. So they set out a lot of parameters, but they still allow you to fire and hire at any time. But most employment agreements, they're going to have, they're going to be for a set term. They're going to define pay, they're going to define benefits, and they're going to define the situations that somebody can be terminated or leave the job and what that looks like. And so if I'm an employer, I know that I've hired this person and they're going to be with me, for a year or 2 years or whatever that term looks like. I know that we've agreed that they have to give me 30 days notice. I know that they've agreed to a certain salary, a certain bonus compensation, all of those things. And as an employer, I'm going to follow it. The same thing from an employee. They know they've come in and they've been assured that unless they do something really bad and give a for cause reason for a termination, they're going to have a job for a set period of time. Maybe it's a year, maybe it's 2 years or some other length. They're going to know that if the employer decides they want to terminate them, they usually have to provide some notice. They're going to know what their benefits are. They're going to know what their salary is. They're bonus eligible. They may have a plan for that bonus. So it's really about giving some certainty in the position and a kind of a plan going forward. And that benefits both sides.
And when we look at both sides, you laid out quite well a variety of the components, but what should employers and employees both be careful of when signing an agreement?
Part of it is not getting stuck. Some of them, an agreement might be for a long term and it might be difficult for one side or the other to exit. That's, I think, the biggest problem that we see. Somebody comes in, they accept a job, they sign this contract for a couple of years, and then they realize they want to leave. And some of these agreements are written so that perhaps the only way that a person can leave their job is if the other side isn't performing, as an employer, they can only terminate them if the person's done something for cause. As the employee, they can only do it if the employer, isn't following their responsibilities. Or let's say it's a long agreement and the pay scale is something that isn't good ultimately. It was good for 1 year, but then the employee wants to change it for the next year and they really have no negotiating power because they signed a 5-year contract. So it's really, I think it can be easy to come into a job you really want, to see a contract and just think, oh, that'll be good enough. They said that it's a 5-year contract, but we can look at it again next year. Next year rolls around and the other party isn't willing to do it. So those are some big things that you need to look for. Another provision that's really important from the employer side is confidentiality provisions. Somebody needs to really think about, what do I do to protect the information that I'm sharing with my employees? Part of the reason that often contracts are given is when an employer's got private information that they want to protect. So that would be a confidentiality provision. And there are also intellectual property provisions that can be very important for employers if they're a company that is developing some kind of material or intellectual property. On the employee side, particularly if you're being hired to develop, you need to study those provisions really carefully because often the things that you make for an employer are owned by that employer, but you need to think about if things that are made outside your employment are often being owned by them. So those are the provisions that can be really long and hairy looking. It can be really easy to skip over them and just sign a contract because you want the job, and you find yourself really in a problematic situation a year or 2 years down the road whenever you get a better opportunity and you're bound by this contract that you never thought was going to be an issue, and now it's a problem.
I think a lot of us have found ourselves in that situation. So just curious, so there's the NDA component. Can you detail for us the non-compete clause aspect?
Absolutely. So non-competes, as you probably know, are a big question mark right now. But traditionally, we would see in a lot of employment agreements a non-compete agreement. So that is going to talk about who you can work for after you leave. Generally speaking, can you go and compete with this business? In Texas, they have to be reasonably restrictive in time, in geographic scope, and in what they're preventing you from doing. So our courts have interpreted them to keep them as narrow as possible to protect the business and then allow that person to go work in an industry. So the example I always use for people whenever they're developing non-compete agreements is if I'm Pepsi I can hire a marketing executive and I can write a non-compete that says you can't compete in the global snack food industry for 2 years, or the global soft drink industry, for 2 years around the world, right? You can't do marketing for us. But I can't, or for another global soft drink company. But I can't say you can't do any marketing worldwide, because there's a whole host of companies you go to work for that wouldn't affect my industry at all. I can't keep you from just going and doing the job you've been trained for. I can keep you from going and working for my direct competitor and using those skills and experience to hurt my business. So that's a really common provision in a lot of contracts, especially for key people. It's different than the confidentiality. So confidentiality, we're going to protect our information. Non-compete, we're going to say you can't go do business that interferes with our business, that competes with us. And then we have non-solicitation agreements that say you can't take my other employees. So you can't leave, go work for a competitor or anybody else, and then start taking my employees, start taking my contractors, taking all of those people with you. So those are three pretty key components that have been in a lot of contracts. This spring, the Federal Trade Commission issued a ruling that proposes banning non-competes. And if it remains, if it's not struck down by a court ruling, it will go into effect on September 4th. There are currently a few lawsuits pending, and I think everyone expects that there will be an injunction or some ruling so that it does not go into effect on September 4th. So where we sit today, I tell people that want non-competes, so we can put them in the contracts, and we're adding specific language that says if that ruling or a ruling similar to that comes into effect, it doesn't invalidate the rest of this contract, that we just are agreeing to remove this provision if that happens. But you still can't have non-competes right now. And until we know for sure that it's not been struck down, though, we can expect on September 4th that non-competes in most instances will be invalid.
So 2 points on that. Will previous non-competes also be invalidated? And then who will still be subject to the non-compete clause?
Yeah, most non-competes will be invalid at that point. However, there's a carve out for certain key executive employees. So if you have folks, bound by non-competes and this does come into play, you're going to want to take a look at this provision, because your leadership, your innovators and higher salary folks, their non-competes may still be effective after that date. Also, this doesn't apply if you have a non-compete agreement that was part of a business transaction. So two businesses, there was a merger, there was a sale of business, and they've agreed not to compete. That's separate. This just deals with employees. So there are folks, and really they're the people that non-compete legislation was made for, that at least for some period of time after the ruling goes into place, it still can impact them. But if the ruling does come into place, employers will be responsible for notifying those employees and former employees whose non-competes are no longer valid. We actually there's going to be a deadline to send them a notice and tell them, by the way, you're not affected by this non-compete anymore. The other really important thing, though, is that this doesn't apply to non-solicitation agreements. So you can still have a non-solicit, it just can't be a non-solicit that works as a non-compete. So if it says you can't solicit my customers, well, the court's probably going to determine that that's a hidden non-compete in a non-solicitation agreement.
Okay, so a lot of layers within layers there.
Absolutely. We're all having to be really careful how we draft things and prepare to, change them and on a moment's notice as we get closer to that date.
So let's jump to the other big piece of information you get when you're hired, employee handbooks. Can you detail for us some of the difference between an employee handbook and an employee contract?
Absolutely. So handbooks shouldn't be contracts. This is something that you want to be careful about. Again, if you're grabbing materials offline, anytime I'm drafting one, I make sure to put in there, this is not a contract. I put a lot of the employer may do this. The employer can do this. It shouldn't be binding on the employer. So that's one of the big differences. We're going to have a contract out there that's going to define rights and be contractually enforceable, meaning you can file a lawsuit with it if somebody violates it. A handbook's not going to be that way. When you think about an agreement, is there a contract that's going to, I'm just really quickly, I'm using those two words interchangeably because, we take a couple of classes in law school to learn if something is a contract or not. If you draft something and give it to an employee and you call it an agreement or you can call it a contract, I promise you somebody is going to try to claim it's enforceable. So we're just assuming that, all these legal arguments about enforceability aside, that it's an enforceable contract. But that's an agreement between two people that's going to define those two people's relationship. Handbook is used with all of your employees as a guide for kind of what their rights are, what their expectations are, it's a better word than rights, what their benefits are, and what you expect of them. So while it's not a binding document and you want to put something in there that says this does not create a contract of employment, especially if you have at-will employees, it's going to talk about, what vacation they get, what their insurance is, what your policies on behavior, on how you dress, just your general expectations of your employees. That's what's going to be in your handbook. And it's kind of like the contract. There are some situations where you want them and some where you don't. If you're not going to follow a handbook as an employer, then don't have one. I would much rather have somebody just say, we don't have a handbook. We just kind of have set guidelines and rules that we talk about, than to come in and say, I've got this handbook, it's 47 pages, and we don't really follow it.
Would you say that in that way, the handbook can almost create more confusion than it's worth sometimes?
Absolutely. And sometimes it creates litigation points. If we treat people differently, there are not a lot of claims in employment, especially in Texas, but there are those discrimination complaints. And so it can be really easy to not even realize you're doing it and treat different people differently and inadvertently create a claim for somebody. I'm a woman and you didn't give me time off for this reason, and you gave my male counterpart the same time off. And it could be a well-intending company owner who didn't even remember what he did for one person or she did for one versus the other, and they've suddenly created a claim for themselves. So if you're going to have those guidelines out there, you really need to follow them. A company with 10 employees should not have a 47-page employment handbook. A company with 1,000 should probably have a pretty lengthy handbook.
So as we wrap up, we've covered a lot of territories across employment. Would you have one major piece of advice for employers and then one major piece of advice for employees as we wrap?
Absolutely. So for employers, be really thoughtful about the documents that you use for employees. I think it's really easy to read an article, go to a conference, or talk to a friend and think you need a bunch of contracts, a lengthy handbook, and not really put thought into whether it's right for your business. These documents are just as important as other, enforceable, loans you sign, or the documents you use to form your business. These agreements with your employees are really, really important. And so if you choose to have them, you need to be tactical about your decision to have them and be thoughtful about the provisions that are in there. And kind of the other side of that coin for employees is read what's put in front of you and really think about, especially if you're given an employment agreement or contract, whether or not that makes sense for you, not just today, but in the future, because you can find your hands tied behind your back and you unable to make changes in this job or go seek future jobs that you might want because of the terms that you sign now.
Perfect. I think it's a great point to wrap up on. Everybody, thanks so much for listening to Deals and Disputes with the West Webb Law Group. For more information, you can connect with Baili Rhodes and their incredible legal team. Check out westweblaw.com and find them on social media. Baili, thanks so much for your time today.
Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.